Mr. Chairman and distinguished members, thank you for the opportunity to testify today in favor of the National Right to Work Act. My name is Jeanette Geary. I am a nurse by profession. I have spent my entire career in direct patient care, always devoted to my patients. Many years ago, when I was working at the Kent Hospital in Warwick, Rhode Island, there existed a nurses' union called the United Nurses and Allied Professionals, UNAP. I initially supported that union, but events I witnessed quickly soured me on the union. First, at one of the union's wine and dine recruitment events, a high union official stated that the union's goal was to be able to walk into any healthcare institution in America, find the administrators, and declare they were representing the employees with no election. This would remove the ability of every nurse to talk with their managers and administrators regarding their own jobs. Additionally, I witnessed that UNAP representatives and officers were allowed to freely roam the hospital and push the union's political and social agenda, which was not the nurses' agenda. These union officials let opponents of the union know that any grievances they filed would be ignored and that difficult work assignments would be given to those who opposed the union. As I evolved to become an opponent of this union, I was only allowed a small corner in the hospital cafeteria during non-cafeteria hours and on my own time to give nurses another point of view. I eventually learned of my rights under the Supreme Court's Beck decision, but not from UNAP, which had no incentive to tell employees what their true legal rights were. When I finally became a non-member of UNAP and invoked my Beck rights, the union refused to acknowledge me, belittled me, and refused to provide any audited financial disclosure about what it did with the compulsory dues it forcibly extracted from my salary on pain of discharge. Having nowhere to turn, I found the National Right to Work Legal Defense Foundation, which agreed to represent me to ensure my Beck rights were protected. Little did we know this would end up being a 12-year legal battle that was litigated up and down the National Labor Relations Board chain and in two separate United States Court of Appeals circuits, just to secure the proper dues reduction that I was owed in accordance with Supreme Court precedent. As my written testimony details, my litigation against this union took over 12 years in two separate United States Court of Appeals. After I resigned my membership and objected to pay for the union's political and non-representational activities under the Beck decision, the union refused to give us audited financial disclosure of how it spent our dues, and in fact, spent our forced dues money lobbying the Rhode Island and Vermont legislatures. With the Foundation's representation, I initiated an unfair labor practice charge against UNAP with the NLRB on November 23, 2009. That began my 12-year odyssey to protect my rights. My 12 years of litigation proves that the Beck objection system is broken and does not protect employees' rights to refrain from funding union politics and union-endorsed politicians. Unions do not tell employees about their rights because they have no incentive to do so. And regular employees like me cannot afford to take on these legal battles by themselves. Without lawyers like the National Right to Work Legal Foundation, we are left to fend for ourselves against unions that have no regard for the law or Supreme Court precedent. For all of these reasons, I wholeheartedly support the National Right to Work Act so that no employee will be forced to pay his or her hard-earned money to a private and unaccountable organization they do not support. This is America, and membership in a union and payment of dues should be strictly voluntary. Employees can make their own decisions about whether they are benefited or harmed by the union that has been installed in their workplace. Thank you for your attention.